Now let's talk about parties to the sale. What is the general rule? The general rule is that every person having legal capacity to obligate himself may validly enter into a contract of sale, whether as seller or as buyer. What about contracts entered by legally incapacitated persons, such as minors, insane and demented persons, and deaf mutes? These contracts are voidable and thus subject to annulment or ratification. Take note that the action for annulment cannot be instituted by the person who is capacitated, since he is disqualified from alleging the incapacity of the person with whom he contracts. What if necessaries such as sustenance, dwelling, clothing, medicines, books for education, and transportation services are sold to a legally incapacitated person? This contract is considered as valid, and thus the incapacitated person must pay a reasonable price therefore. But remember that in order for this contract to be valid, there must be perfection of sale and delivery of the subject necessaries. If there is no delivery, then the contract is voidable. Now let's talk about sales by one of the spouses. Let's say the husband sold the conjugal property to a third person. Without the wife's consent, that contract is void. But the husband may dispose of conjugal property without wife's consent when necessary to answer for conjugal liabilities. In that case, the contract is valid. Take note also that if the wife signs as a witness in a deed of sale, she is deemed to have given her consent, thus making the contract valid. What about sales between spouses? Sales between spouses who are not governed by a complete separation of property regime are void. This rule also applies to common law relationships. Now, what if the husband sold the conjugal property to his concubine? That contract is also considered void for being subversive of the stability of the family. Now let's talk about buyers who are relatively disqualified to enter into a contract of sale. As to the administrator or executor with respect to the property of the estate of the deceased, hereditary rights are not included in the prohibition. As to the agent with respect to the property of the principal entrusted to him, if the principal consents to the sale of the agent, then the prohibition no longer applies. As to the lawyer with respect to the property which may be the object of litigation, if the lawyer bought the property prior to the time he intervened as counsel, then the prohibition does not apply. As to the judge, with respect to the property in litigation before his court, if he bought the property after the judgment became final, then the prohibition no longer applies. So that's it for our review on the parties to the sale. Thank you for listening.